Good to have you join me on a fresh edition of Law and You, where we take our time to look at the nitty-gritty about the law as it applies to some concepts that need to throw light upon in terms of bringing light into such gray areas that they may tend to pose. And today we are looking at the issue of elections and defections. Who owns the vote? Is it the party candidate or the political party? You agree with me that there has been this build-up in our electoral process and cases in court, to look at or determine if the party or political party, have the votes or the votes belong to the party candidates. And discussing this sensitive issue with me on the program Law and You is a legal practitioner, Matthew Edelase. Thanks for joining me.
Thanks, Philip, for having me.
All right, let's look at it critically. We know that developments are popping up in this direction in terms of the law courts incident cases on determining who owns the votes. Is it political parties or party candidates at the point of defections?
Under our electoral system and the extant electoral laws and even the constitution of this country, the party owns the votes. Candidates contest on that party's platform, political platform. Party sponsor candidates.
Okay.
There's no pressure for independence candidature. So any candidate that wins an election under a party is an agent of the party. He contested under the platform of that party. The vote belongs to the party. Though he occupies the seat, he does so in trust for the party.
Okay.
That is why he contests with the party manifesto. Manifestos are not documents of candidates. They are documents of the party under which he was elected. And it's expected to implement the provision, the content of that manifesto upon assumption of office if he wins. So you can see from the analysis that the party owns the mandate and the candidate holding it in trust for them.
Okay, but we've seen in cases where it is the otherwise, where it is being explained that the party candidates, own the votes. We've seen that in some cases, and where after elections, cases are brought to the court, and then some courts give verdict, to the fact that the party candidates own the votes. What do you make of this change or differences in the cases that we've seen so far?
I am not aware of any court decision to the effect that the candidate owns the votes. What has happened before now is that there are technicalities.
Okay.
As to whether the law stipulates that the occupant of that seat, most especially the executive organ, arm of government, the president, the governor, should lose their seats by reason of their defection to another party.
Yes.
The argument has been that that provision only applies to the legislative arms, the legislators. That upon defection, they lose the mandate. The mandate reverts to the party. That is what the court have pronounced upon before now. But for the executive, there is this argument that that provision that provides for vacating the seat upon defection does not apply to the executive expressly under the constitution, the relevant provision. So it is through that window they have been escaping the hammer. That is the executive.
Okay.
For the legislature, they have been series of judgments declaring their seat vacant.
Okay, but do we have all of this as provisions of the law?
Yes, they are there. They are enshrined in our constitution. The extant provisions are there.
Okay.
So the question is not whether they will lose their seats by reason of
defection.
The question is the enforcement. Ordinarily, it is the speaker that should pronounce the declaration of the vacancy of that seat. And most of the time, the ruling party are the one receiving the defectors. So the speaker will refuse to do his legislative duty by making that pronouncement. Instead, they will condone it because they benefit its own party. That has been the problem. It is not a question of absence of the law. It is the question of the will to enforce the law. That has been the issue.
Okay, we've seen cases, we've looked at issues where there have been too much of defections among our political parties, and the need to bring sanity in this direction. But don't you think there should be laws that will establish it stricto sensu about the need to discourage this aspect of defection in political parties by instituting that the moment one, defect from one party to another, be it executive or at the legislature, it loses the office. Don't you think that should go a long way to correct
that? Should have been the
trend?
Proper thing to block the loophole that is evident in the extant provisions.
Yes.
Because giving the power to declare a seat vacant to a partisan political actor, if it profits him, he's not going to trigger that power. He won't exercise it. Then we will be moving in circles. The law should be enacted in such a way that it will be automatic. Once you defect, you lose your seat. You don't need anybody to make a pronouncement. Declare your seat vacant, which they have refused to do till date, the speakers, both at the national and state level. They don't do it because they profit. Because they cannot even appropriate and they can't declare, they can't pick and choose.
Okay.
Because defection most of the time goes both ways. But it goes more in the direction of the party in power that normally produce the head of the parliament. So they refuse to exercise that. Because they also cannot exercise against the opposition if it goes the other way. Because that will mean you must also, what is sought for the goose should be sought for the gander. So for that reason, they just leave it there.
Should it be solely left in their hands to determine, or how should it be done? How can the constituency or the Congress or the people come in to make sure that this is established? Because if you had to leave it in the hands of the legislators, to go about this in order to bring it to fusion as laws, then if it happens that it doesn't favor them, they may stay aloof away from it. But how do we tackle this outside them, influence and such?
There's really nothing you can do because they are the lawmakers. And if the law does not capture a particular act and provide sanctions, you cannot do anything as a private citizen. You can't enforce your will. You can only enforce the law. If not that the Electoral Act was passed and assented to, we wouldn't be talking of the reform we are experiencing today in the electoral system. So the law is very important. It is the tool upon which you can build any rights.
Okay.
And invoke any sanction. So what we need to do is to put pressure on the legislators as private citizens to do what is right. Tinker with the relevant provision, make some amendments. As we speak, there is a proviso that when you defect and there is division in the party, you will still retain your seats.
Okay, that's a proviso.
Yes.
If there is division in the party.
And what they now do...
So legislators can gain in that process.
Yes, they take advantage of that window. And there's no consequence. So what that means is that if they want to defer, they can cause confusion. They create and generate crisis. So they will now establish that foundation of a crisis.
Okay.
So when they go, they say, didn't you notice that there's crisis? There are factions. So they factionalize the party. That's why you are seeing all the parties are most in crisis.
Okay, but there's an extent at which one can go to establish that there's a crisis in the party. So
division.
To what extent can we say? Is it just factionalization alone?
Yes, when there are two parallel leadership.
What about if the parallel leadership is only at the state level and not at the national level?
When the politics is local, everybody comes from a constituency, even the National Assembly officials. So if there is division in your own area, that is what you need to trigger that your exercise of that right.
In that locality?
Yes. Every legislator came from a constituency. They came from a state. So if there is division, there is crisis at that level, they can take advantage of that. To say, you see, I could not have been floating without a party. have to go to where I will find stability. It's not my fault. I was compelled by circumstance or the political situation to take this decision.
Okay. What do you see, because we can't talk about this without looking at internal democracy in political parties and how to make sure that works in order not to fuel the appetite for us to have these challenges that we are faced with as it pertains to defections. Now, what do you see as missing in political parties, having these issues of not having unity among themselves in terms of having internal democracy? What do you think is missing, and how do you think that can be tackled at the local level in politics?
It is triggered by the desperation for power among the political actors, and this tendency to acquire power at all costs by every means necessary. Most people who are parade themselves in the political space, they are not democratically minded. They are not Democrats. And once you don't have the mind of a Democrat and you are in a democracy, you are bound to play the politics of adulterating the process. And adulteration of a process means the process is no longer what it ought to be. Tyranny has been incorporated into our democratic culture. Fascism has been introduced. You hear somebody saying, I won't allow any opposition to put a billboard here. That is not democracy. That is fascism. Anybody who does not agree with, who does not vote for my party will be chased out of this state. That is totalitarianism. All these have become a mix in our peculiar circumstance. Until we play democracy by the rules, we will begin to notice this aberration on democratic activities,
okay,
which is putting pressure on our democratic growth negatively.
Okay, let's look at the process at which we can make a change in terms of legislations. You said earlier it has to do with the legislators, the House of Assembly, the National Assembly. At what point, or what is the process that it could go through in terms of amending the provisions of the law to shaping in a way that it could discourage defections in political parties?
It ordinarily should have been a natural process, okay, of
sponsoring a bill,
of democratic evolution.
Okay.
Laws are amended to suit the exigencies of the period. If laws are outdated, they are no longer meeting the need of the time. All over the world, the need to amend will arise. But in Nigeria, you saw how long it took for the Electoral Act to see the light of the day. Even when it was eventually passed after such a long wait, it took another longer wait for the president to even append the signature. Before he eventually did, he have to even started re-amending and sending the draft copy back to the parliamentarians. And when they did what they had to do, the president also have to waste enough time. At a point, even after it was eventually assented, executive went to court through the Attorney General, challenging the enforcement of the provision of the certain provisions of the enacted law. So you can see the political actors, out of desperation, always find a way to frustrate the process of smooth running of the electoral system. Now it is left for the people, the electorate, to exercise so much wisdom in picking or electing who to represent them, because that is where the foundation of the problem is. If you vote for people who are not public spirited, who are not, who do not have the kind of patriotic zeal to make the system work for everybody, you are likely to have people who will continue to frustrate every move that will make a system work for everybody. So at the point of election, this is the campaign period now. This is where to set the record straight. Put your mind right towards electing candidates that has credibility and competence and strength of character to do the right thing at all times. If you vote for somebody who is antisocial, who does not believe in public good, by record and antecedent. Don't expect miracle to happen. Power will not change people. Power will only reveal who they are. That was the words of Michelle Obama. If you are a hardened criminal, making you an elective office holder, political office holder, does not make you a saint. It will make you a more sophisticated criminal. You will deploy your character towards negative views. If you are somebody who has been a philanthropist, giving your hard-earned money to solve public needs, voluntarily, without any pressure, you are most unlikely to want to steal public funds meant for developmental projects.
Yes.
Because you have been putting your money to do this. So it will be double opportunity for you to further exhibit your philanthropic gesture when you are given public funds to manage. Okay. If you have been a known fraudster, there was a revelation in Kogi recently. A candidate for the NNPP, the Conquest Party, has been arrested by EFCC, busted. They swindled Union Bank to the tune of 1.4 billion. They recovered 300 something million cash in his house upon arrest, and another 140 something thousand US dollars. Is a candidate for House of Assembly in that state. So if you vote for such a character to go and represent you and your interest, are you not putting your interest in serious jeopardy and danger? So this is where the problem is. We must scrutinize the character of candidates before we cast our votes. We should not allow people to buy your conscience, impress you with illicit funds. You begin to say, oh, this man is very ready for the election. Look at the way he's throwing cash. Look, throwing cash is not the readiness for election. It's a readiness for business. Okay.
Let's look at the aspect of political ideology that seems to be absent in this generation of political parties that we have. Now, in tackling this menace of defections, how can the law, bring about a balance in terms of ensuring that political parties are ideologically based? Do you see a window that the law can also use in terms of making it, bringing a balance in this direction?
I've said before now that once the law is explicit, the law should not create room for ambiguity when you are interpreting it. For instance, the provision says once you defect as a legislative office holder, you will lose your seat unless there is evidence of fashion in your party. That provision did not mention the executive organ.
No.
That is the window they are taking to escape sanction and consequence. There is nothing stopping the lawmakers to amend that provision to say expressly, any elected office holder, political office holder,
be it in the executive or in the legislature.
Yes, expressly. No room for ambiguity, for technicalities. Automatically, we have a seat declared vacant upon defection. There is even nothing to stop the lawmaker from saying there should be no ground whatsoever under any guise. If you decamp, you lose your seat. You stand for a fresh election if you test, if you know you're confident about your popularity. After all, the mandate belongs to the people. So if you are moving, you should need their consent to move with it. You can't move without reverting to the owner of the mandate. Because you're holding this mandate in trust on behalf of the electorate who voted for you. They didn't vote for Philip under Party A, only to end up with the mandate in Party B, which they have the opportunity to vote for if they wanted to vote for that party. You are not taking mandate from Party A to Party B against the will of those who voted for Party A, upon which mandate you now become an elective office holder. So let it be expressly stated that any movement of an elective office holder from one party political to another must get the fresh revalidation at the pool by the electorate. There should be a rerun. A rerun should be declared immediately. All this one were not stated in the laws. They are lacunas, which the political class are now smartly exploiting to our collective detriment.
All right, in case you're just joining us, it's Law and You, and we are looking at the topic before us, which is election and defections. Who owns the vote? And I've been discussing with a custodian of the law, Matthew Ederase. Now, let's stretch this further, looking at the need to sponsor some bills in this direction in order to bring about a balance. Can individuals sponsor the bill in terms of making such changes, or groups?
Definitely. You have private member bill.
Okay.
You have bill that can be sponsored by you and myself, or
to make an amendment.
Yes.
To this act.
For instance, the current electoral act, there was a lot of input made by civil society organizations, CSOs. All those beavers and all of that, all those critical inputs, they were made by CSO after a long period of research, which they forwarded during public hearing to the committees of the National Assembly, which now gave flesh and muscles that is now giving us some ray of hope in this electoral tunnel that we have been.
Okay.
So it's not a play for individuals or groups to sponsor a bill based on their findings, identified loopholes in any existing laws.
Okay. Okay.
It is done. Right. But the problem with that is that if you push a bill to the National Assembly for passage, it has to pass through the processes. If you do not win the buy of the people who are going to debate and vote for the passage of the bill through the 3 stages,
yes, of course,
it will die naturally. So it is even, that is why it is
so
more
there has
advisable.
to be a lot of lobbying.
Yes. And if you are not having the kind of political muscle, you really cannot go far to lobby people of divergent political interests.
So when you say political muscle and when we talk about lobbying, we are not talking about,
that is why
we're not talking about bringing money into
no.
Okay.
No. Being able to convince people,
convince.
As a private person, people who have political cleavages, they have allegiance to their parties and political ideologies.
That's a whole lot.
Yes. So it's safer it comes from within the political class. For instance, the political parties. If a party preaches restructuring their manifesto, it's easier for that party to push that restructuring through their members at the National Assembly, they are the majority, than for you, an individual, to push it in from the outside. Because they will shoot it down.
They will shoot it down.
That is the problem.
Okay. Let's look at the aspect where even if it survives the first, second, and third reading, and then you send it to the president for assent. At the point, such frustrations could also be seen where the president will refuse to give an assent. Now, what do you make of this? What would be the process after which the president refused to give an assent? What should be done in that regard afterwards? After
a long period, a stipulated period, as provided by the laws, it automatically becomes the law.
The law?
Yes. Because the president executive cannot stampede the acts of the body or representative of the entire nation. Because if you're talking about representation, it is domiciled in the National Assembly. The two chambers.
Okay.
They come from across the country, representing each and every constituency. President is only one person. People speak through their representatives. So the law is so crafted that if the president decides to frustrate the will of the people's will prevail. That is why he can only delay the assent. He cannot stop the law.
But if he refused to give an assent and he gives logical reasons why he refused to give an assent, does that make the National Assembly to veto that?
The reason president gives for declining assent, it stops at not giving his assent.
Yes.
It does not stop the law from being invoked.
No matter how laudable the reasons
are. It's not a monopolist of wisdom. He cannot be wiser than all the sum total of everybody at the National Assembly representing the director of the public. What happens is that these people become politically compromised. They become so partisan in terms of inclination towards their party. They don't want to override the president's veto. That is the problem.
Okay.
The power is there. They refuse to exercise it.
Okay.
They felt they don't want to embarrass the president. That was what happened in the last case. Buhari wouldn't have been able to delay that thing as much as he did, conditioning them to be retickling with what they have already done to the extent that he will not be satisfied. The law is not to be made to the satisfaction of the president. That's an aberration in other democracy. That's a totalitarian tendency. It's only an authoritarian leader that will say, if I don't like it, it will not happen. Democracy is, if the people are happy, majority are happy with it, it is good. A majority can be found at the National Assembly through the majority vote there.
Okay, so largely, as we round off, what are you saying concerning who owns the votes, the political party or the party candidates? The
law is clear. There is no independent candidacy under our electoral act. The votes belong to the people who cast the votes.
All right.
And they cast their votes through the party.
Through the party.
That's why you hear a party in power and a party that is in opposition. Individual cannot be in opposition. You don't have opposition person. You have opposition party.
Among parties.
Yes.
Thank you so much for taking our time to be part of this discussion. Well, this is what we call it a wrap on today's edition of Law and You. We see you on the next one. I am Philip Omo Gyukbong. Goodbye and have a